Okay, international law. International law is really broad. Refers to the body of rules and principles that govern the relation and conduct of nations, international organizations, and in some cases, individuals and companies. It covers a wide range of issues such as human rights, trade, environmental protection, and conflict resolution, as well as commerce. International treaties and conventions are probably the primary source of international law. These are formally, legally binding agreements between states or international organizations that outline specific rights and obligations, such as the Paris Climate Accord, the Geneva Conventions governing the treatment of combatants and civilians during war, or the United Nations Charter. We also have international custom or customary international law, and these are the practices and norms that states consistently follow out of a sense of legal obligation. These customs are considered binding even if they're not written in treaties. And so customary law really fills in the gaps when there's no treaty in place and it applies universally. So for example, prohibition of torture and genocide are generally considered customary international law. These are customs that we follow out of a sense of legal obligation to our citizens and to the citizens of other countries. General principles of law are the fundamental principles that are recognized by most national legal systems and are applied in the international legal system. These principles ensure justice, equity, fairness, where treaties and customs may not cover specific issues. So for example, the principle of good faith in an international agreement is a general principle of law, as we know from contract law. Decisions by international courts, such as the International Court of Justice or the International Criminal Court, and the opinions of leading legal scholars serve as secondary sources that clarify or interpret the law. So these aren't necessarily binding, but they influence the development of international legal norms. And then resolutions of international organizations, non-binding declarations, resolutions, and recommendations from international bodies like the UN or the European Union. These can be binding or non-binding, but their resolutions offer shape and development of international norms that guide state behaviors, such as the UN Resolution on Human Rights or climate change goals. And then bilateral or multilateral agreements. Agreements between two or more countries to regulate specific matters such as trade, security, and environmental protection. So like NAFTA or the USMCA, which took over for NAFTA, United States, Mexico, Canada, USMCA, United States, Mexico, Canada, Commerce Agreement, I forget. USMCA is what we know it as. Or the Kyoto Protocol, which was designed to influence climate. The U.S. never signed on to that, so it was agreed to. It was a treaty that was agreed to by President Clinton that the U.S. never fully adopted. These agreements can sometimes be sources of customary international law when widely practiced by many states. Some international law organizations. The UN is the largest international organization responsible for promoting peace, security, and cooperations among nations. Its agencies like the Security Council and General Assembly play crucial roles in shaping international law. The World Trade Organization governs international trade relations and settles trade disputes between member nations. When two nations have a dispute, like say that Norway and Denmark are having a dispute over a fishery in the North Sea, they would take that dispute to the World Trade Court, who would convene a group of non-affected nations to adjudicate the dispute. The IMF and World Bank are institutions that regulate economic policy and lending and financial stability between nations, influencing international financial law. The IMF is generally the lender of last resort for countries that are in big financial trouble. And generally when the IMF lends money, they require a combination of economic and political reforms in order as a condition of receiving funding. And then regional organizations like the European Union, the African Union, help to establish regional norms that apply to their member states. A non-state has jurisdiction to make and enforce laws within its own borders, with respect to its own citizens, and with respect to actions taking place outside the territory but having an objective or direct impact within that territory. So basically what that means is, as a United States citizen, you are subject to United States laws wherever you go in the world. You are also subject to the laws of the place wherever you go. So if you go to a foreign country and do something that violates United States law, you can be prosecuted by the United States for that. This comes from the Third Restatement of Foreign Relations, which is an academic work. And these jurisdictional bases are known as the territorial principle, the nationality principle, and the objective territoriality principle. Don't need to know that, but you do need to know that as a U.S. citizen, you are subject to United States laws wherever you go in the world. Forum nonconvenience is a judicial doctrine that helps to determine the proper forum when courts of two nation states can claim jurisdiction. And so basically what happens is the court may or may not decline to hear a case if another country's courts are better suited to adjudicate the dispute. In contract law and international contract law, choice of forum is always listed in the contract. So I know that if I am an American company and I'm dealing with a British company, it's going to say in the contract where the forum is that disputes are going to be heard: United States or the UK. And so that is a choice of forum selection. Sovereign immunity is the principle that a state or its officials cannot be sued in the courts of another country without their consent. The families of the folks who died in the World Trade Center from September 11th have long tried to sue the government of Saudi Arabia because there is evidence that the government of Saudi Arabia was involved in funding those terror attacks. However, the Saudis have successfully argued in court that they cannot be sued because they are a sovereign nation and have sovereign immunity. Individuals from that government can, however, be sued if they could be identified. And then in terms of international law, we also have trade regulation. I'm going to give you a couple of separate videos on trade regulation that discuss import controls, tariffs and trade agreements. And then the Export Administration Act of 1985 is a piece of legislation that basically says that the United States government can limit the activities of businesses. They can limit who you export to. So if I'm selling aircraft parts, for example, or anything really, they can embargo certain products so that those products cannot be sold to combatant countries. So I can't export my aircraft parts to Iran, for example. And so that is the Export Administration Control Act of 1985. And so with international law, that's kind of the overview. I'm going to give you a couple of really good videos to watch as part of this lecture. And so just consider them to be special guest star lectures addressing things like export and the World Trade Organization and some really important elements of international law with respect to trade.